The reality of financial distress creeps in slowly and then all at once. It often begins as suspicion, then it becomes fact. A business simply cannot pay its creditors on time. Understanding the causes and impact of financial distress is critical to selecting the right response. As a rule of thumb, directors and managers of businesses in Zimbabwe, especially SMEs and family-owned companies, must develop the discipline of performing the financial distress test. This test, prescribed under the Insolvency Act, acts as an early warning sign. It helps predict whether insolvency is looming, and it gives directors time to react strategically by choosing the most appropriate insolvency option. I am Calverwell, and I help SMEs manage restructuring and create the clarity they need to grow with confidence. This session unpacks how compromises are negotiated, approved, and made binding. Of the 3 insolvency options available, one is creditor compromise. Section 147 of the Insolvency Act provides for this. A creditor compromise is an arrangement proposed by the business to its creditors, asking them to agree to revise terms for discharging financial obligations. In simple terms, any adjustment to the terms of a financial obligation is a compromise. But fairness is essential. A compromise must present a quid pro quo. For example, a creditor or a class of creditors may reduce their claims in exchange for greater certainty of payment. It is not about escape, it is about balance. Compromise has distinct features that make it a powerful tool. 1, there is no requirement for insolvency or financial distress. It can even be used by solvent businesses to restructure debt and avoid liquidation costs and stigma. 2, it can be applied when other insolvency proceedings are underway. The only exemption, a company already under corporate rescue cannot propose a compromise. 3, it is flexible. A compromise may target a specific class of creditors with no regard to ranking of claims. A class of creditors is a group with similar rights and interests. For example, trade creditors may be compromised, while other creditors are excluded. But caution is required. If creditors are misclassified, the entire compromise risks being invalid. This flexibility, however, creates room for negotiation and helps preserve both business and transactional value. To effect a compromise, the Insolvency Act prescribes specific steps. The directors or a liquidator in the case of an insolvent estate must draft a proposal. The proposal must contain 3 key parts. Part A, background. This includes the list of assets, creditors, shareholders, and the probable dividend if the company were liquidated. Part B, proposals. This sets out the moratorium terms, the extent of financial compromise or debt-to-equity conversions, treatment of contracts, assets made available for creditor claims, and why the creditor should adopt the compromise over liquidation. Part C, assumptions and conditions, which covers operational conditions, effects on employees and employment terms, and projected financials. Finally, a certificate by the director or prescribed officer confirming that all information is accurate, complete, and provided in good faith. Second, the proposal must be shared. It goes to creditors and to the Registrar of Companies together with notice of meeting. Third, at the meeting, the compromise is adopted if 75% in value of creditors in that class vote in favor. Voting may be in person or by proxy. Once adopted, the compromise must be sanctioned by the court. The court will consider whether it is just and equitable. If satisfied, it issues an order. This order must be filed within 5 business days and attached to the company's memorandum of incorporation. The order is final and binding. It binds all creditors or the class of creditors involved from the date it is filed. A creditor compromise only works when it is approached in good faith. Businesses must be fair and realistic. Creditors must weigh carefully whether the compromise offers better recovery prospects than liquidation. If your business is facing financial challenges, do not wait until it's too late. Explore the use of creditor compromise and secure the future of your company.